Now continuing for the legal update, we have federal estate tax changes. So here we've had tax reform as part of the current administration. We've updated plans to accommodate for any tax changes considering our estate tax exemption amounts. Current plans will work. The additional new information and new legislative changes on the federal front are the Secure Act. We're not going to even touch on the CARES Act component. We will probably have more information to share about that separately, as that impacts all of our retirement plan distributions. So what's the law now? This year, you each have a coupon amount of approximately $11.58 million. Anything above that is taxed at 40%. And that is the same amount of money, whether we die with that in our hands, give it to someone, or pass it on to the grandkids or skip a generation. It's all the same amount of money we have to give away. We can give annually $15,000 without it being reportable. So you can give, each spouse can give $15,000 to a child for a total of, say, $30,000 per child from a husband and wife or a married couple. We still have the ability to port the unused amount of money that we don't have, that we did not use at the first death, to give it to the spouse at the second death. While this is not as important for many clients, since very few are over one coupon amount. However, this law is set to sunset in 2025 on December 31st. So, without action by Congress, the coupon amount will drop to $5 million per person indexed for inflation. This is the flashback to 2012 when the same thing happened. However, the corporate numbers are permanent, so the corporate tax brackets will remain and stay going forward. Now, the question is, there's an election this year, at least so far there's scheduled to be one, and who will be president? So, depending on the administration and who's in Congress, will drive and dictate what these estate tax numbers will be. So, the current front runner, so to speak, on the Democratic Party side, or potentially the only person running in the race at this moment, is Joe Biden. Here's his proposed tax plans as we could find them. And so the taxes in general would be to increase the top bracket back to 39.6%. And then he would eliminate the step up in basis that allows decedents, those that have died, to pass capital gains on to heirs without paying any tax. So I'll rephrase that a little bit and explain. Right now, if someone dies and they own a stock in their individual name, not in their IRA or 401k, and they've owned that stock for a long time, because if they were to sell it, they would have to pay a lot of capital gains on it. And when they die, they step up in basis. So the value of the stock when they sell it is equal to the date of death value. So if the stock is increased although that's questionable given the current market environment. But if it has increased, and then the person, the beneficiary, goes to sell it, they will not pay a capital gains tax on the sale currently. So that's what would be a step up in basis. Let's see. And he has nothing further on estate taxes posted at this point. Many people and pundits say that it would be similar to other programs, maybe perhaps down to 3.5 million, like it was during the Obama administration. So the tax brackets currently look like this. And what we'll want to point out and highlight are in the third column with the heading of trust. So as we've always continually said and raised the issue to some, when you maintain income inside of a trust, it reaches the top bracket with a lesser amount of income. In this instance, over just under $13,000. If the trust earns $13,000, it would be in the 37% bracket. So that sometimes is a concern for clients and the beneficiaries. And this is where we've added what we've termed the cookie jar power. So, what does this power do? And my favorite character on Sesame Street, the Cookie Monster, allows us to accomplish what we've called the best of both worlds planning. So the IRS says that a beneficiary is taxed on income of a trust, even if that income is not withdrawn from the trust. So if we allow our kid to reach into the cookie jar or even open the lid, but not take the cookie, the income in this example, out, as long as they have access, they can be taxed on the income. So that's just not what we want. They get their individual rates, but the cookie or the income can remain in our protective trust for their benefit. So what about capital gains taxes? Well, family trusts, those when the first spouse dies, typically are not included in the surviving spouse's estate. So, based on that, there would be no second step up basis in death. So, what we have now added to almost all of our clients' trusts is a clause known as the bounty clause for the paper towel, not the hunter, which gives us the second step up in basis on the death of the surviving spouse. And what it does is it allows the survivor's coupon has to have some, if they don't have more than $11.58 million, then they can allow this clause to pick up and adjust the basis of the assets in the family trust. So it's some tax planning and some tax provisions that we've placed into the trust to allow us to achieve these objectives. We have an idea of understanding it. We're going to look to probably produce some written materials for you all so you can read about it. I know a number of people say this is tricky, and it is, and we'll do our best to explain it. And also make sure that your kids can understand it because they are the ones that will be handling this when you're gone. So what is the Secure Act? We'll always love how Congress names and comes up with acronyms for bills that have passed. So this one is Setting Every Community Up for Retirement Enhancement Act of 2019. Secure. So believe it or not, it had strong bipartisan support. As you can see, it passed the House with only 3 objections. The bill sat in the Senate for months. We were looking to see if this bill was going to pass much earlier in the year, as early as August. It didn't come about and come back into effect until the spending bill needed to be passed at the end of the year. So, in a hurry, like usual sausage making fashion, it was thrown in as part of that bill, and out it comes. And we're somewhat scrambling to decipher what's in the bill and how did they change a lot of terms. So, here's what the result was: it was not a repeal of the old law. And in fact, it just added a subsection on top of it. So the old rules still apply to a degree that weren't replaced by the new rules. Part of the thought process was Congress intended that retirement plans were for your retirement, not to build an estate for your heirs. And the law now reflects this. The effective date was January 1st of this year. Those who have already turned on they've already turned on their required minimum distributions. So they turned 70 and a half. They're already grandfathered in. So once you've started taking your withdrawals, you're continuing on. And as well as if you've already inherited under an IRA, you're grandfathered in as well. So there's some rules there. So lifetime changes. If you weren't yet 70 and a half and you are in that age gap now, you do not have to take required withdrawals until after 72. There are no age limit contributions, so you can continue contributing even after age 72. However, your qualified charitable deduction is limited by your after age 70 and a half deductible contributions. So that's been a little bit of a change. Beginning this year, you can set up a qualified plan and get deductions for previous year up to the filing deadline, like IRAs typically are. So in this year, we have even extended daylight date, so July 15th. The big rules and the big rule changes that we focused on were after death. So typically, when someone died with an IRA after death, beneficiaries were allowed to stretch out over their lifetime if they are designated beneficiaries. And then if you're a non-designated beneficiary, that would only last and be able to stretch for 5 years. It was the 5-year payout. Now there are 3 types of beneficiaries. They added an eligible designated beneficiaries. So the designated beneficiary stretch out is now limited to only 10 years instead of a person's lifetime. Now, the person has 10 years, including on top of the year the person died, to take all of the IRA monies out. So you do not have to distribute out in year 1 through 9, only 10 years after the date of death. So there's a lot of tax planning that needs to be done in order to coordinate on IRA accounts. And certainly the more money in the IRA, the more important this becomes. If it is a non-designated beneficiary, such as a charity, we're still limited to 5 years only. So this remains unchanged. Now, what is this new eligible designated beneficiary. So it means that you continue to get the lifetime stretch out as it was under the prior law. We have, in our training and some of the stuff we've done, we've used different colored tables. We have blue, yellow, and green. The green is the life expectancy table that we use for when someone dies. So that's what that reference is here. So status of that person, eligible designated beneficiary, is determined at the date of death. And so we still have the ability to do disclaimers if we name a spouse or a trust first. And if the person dies while they've inherited, their stretch out ends at the date of their death, and then the 10-year rule applies from there. So there are 5 types of individuals that qualify. The first is the spouse. The second is a minor child. The third is someone who is disabled or chronically ill, or an individual less than 10 years younger than the participant. They have the ability to stretch out over their lifetime. So for the spouse, the options remain mostly unchanged. They have the right to roll it over and to continue on as if it was their own. They have the right to continue the deceased plan if it is more favorable to them. So these are the options that we have to consider and look at when someone dies, when we do the settlement of the trust. If the child is minor, which in this instance is under the age of 26, then you have the ability to stretch it out only until they become an adult, so to speak, and hit the age of majority if they've stated here. So then after the age of a majority, they have a 10-year rule. So essentially get to 36 for young beneficiaries. If the child is disabled, they get a life expectancy stretch out. So they've defined this as substantially unable to engage in any gainful activity, and the disability is expected to result in death or indefinite period of duration. So again, as you get to on death or end of disability, you have 10 years to distribute. Chronically ill, pretty similar to disabled. And then special rules for trusts. So trusts can be named as a beneficiary for special needs or chronically ill beneficiaries. And so we're allowed to isolate and name a standalone trust for the benefit of that individual, and that will result in the life expectancy rule. And then after the end of that beneficiary's life, 10 years applies. The final, someone that's 10 years younger than the beneficiary, 10 years younger than the plan participant, then you still have the ability to stretch over their lifetime. Mainly, this leads to the thought that since they are not much younger, the government doesn't lose out on its taxes, and it doesn't stretch for much longer anyways. Next, we'll continue with the fee discussion.